Hey everybody, how are you today? We're going to talk about claim and delivery. And we're going to talk about claim and delivery in North Carolina specifically. I practice in Florida, North Carolina, Tennessee, and federal court. The bulk of my practice is in North Carolina because I'm now located in Charlotte, North Carolina. But anyway, claim and delivery is it's a legal theory in a sense. It's also a legal claim. And it's something you don't see very often. And I attended one of these hearings a few months back for a business client of mine who's got a lawsuit going on. And basically what claim and delivery is where you, as part of a lawsuit typically, are going to, not the judge, but to the clerk of court. And you, or the other side, depending on which side you're on, but the entity, that the plaintiff typically, the plaintiff is basically going to the clerk of court and saying, hey, look, the other side has this equipment or this collateral or whatever it might be. It has this asset, and usually collateral is maybe the best terminology to use kind of at a higher level. They've got this collateral, and they've got it because we made a loan, and typically that's the situation you're going to see, and they haven't paid the loan. And it's not really much, a debate about that. And we've done everything that we need to do, legally and procedurally to establish, formally and on the record, such as a UCC filing, with the state of certain collateral. Okay, I'm not going to get into all of that, but basically, even though the lawsuit is still pending and the judge or the jury hasn't decided the lawsuit, in the meantime, we want you to enter an order, clerk of court, stating that we can go and take the collateral. So in some ways, it's a little bit weird because the lawsuit is still pending, and the lawsuit typically is going to involve, at least to some extent, the same collateral. So you think, well, gosh, why would the clerk enter an order saying that one party can take this collateral if the ownership of the collateral is, at least somewhat part of the lawsuit itself? Why don't we just wait till the lawsuit is completed, all right? But on the other hand, you look and you say, well, let me think about like a car repossession, auto repossession. Typically with autos, you can repossess without going to court or filing a lawsuit. And this is kind of a hybrid almost between those two concepts that are a little bit inconsistent with each other, or at least they're different circumstances, right? So claim and delivery, you go to the clerk, say, here's the deal, we want the collateral back, we want it now. And if you do that, and the clerk says, okay, fine, there's a process you have to go through, the defendant can actually come back and post a bond, and there's some bonds back and forth, the sheriff can get involved, and all this and that, and it can get a little kind of complicated. So it's kind of rare, you don't see it that often, but if you're on the plaintiff's side of things, or potentially on the plaintiff's side of things, and there's been a default on a loan agreement or some other type of agreement, and there's collateral there, and again, this is independent of like a foreclosure case and that sort of thing, but there's other types of collateral. It may be that you have a claim and delivery method to get that collateral back, even though the full lawsuit is brand new. Okay, you don't have to wait, months and months and years and all this and that. And so if you can get that collateral back by way of an order from the clerk of court, you've already recaptured something and put, probably additional pressure on the defendant. Now, on the defense side, of course, you're typically going to want to avoid having an order for claim and delivery entered against you, and there's some ways that you can potentially avoid that. On the other hand, if you're on the defense side, and if you don't want the collateral and you kind of want to let them have it, that's an option as well. Although you'd be better off negotiating an overall settlement and making sure that all claims are settled and dismissed as part of the collateral going to the other side. But that's a little bit about claim and delivery. Of course, there are some specifics that are set forth in North Carolina general statutes as well as case law. But I wanted to give you a summary of that in case you've come up against that, or in case you're thinking about becoming involved in a matter that would involve a claim and delivery. So good luck to you out there. Thanks. Bye.